It's pretty exciting, isn't it, to see that?
Here you go.
Got to turn the lights on. I want to take a picture. Okay, excuse me.
Okay, very good.
Hello, Judge Rovner. This is Emily Barney. I am serving as a host of this meeting, and I've put you on mute for the moment. We do have the live stream active, but I will close off the title screen later on. So I can see you, and it looks like your video camera and everything is working fine. I just wanted to let you know why you're on mute at the moment. Judge Rovner, are you able to view the chat for this? I'm going to unmute you for a moment so you can tell me.
Unmute. Can you hear me?
I can hear you, yes.
I don't know how to use the chat.
Okay. I will let Cherish know. She has another. Judge Rovner, are you able to view the chat
another meeting she'd like
for
to have you
this?
join.
I'm going to
So you might check your
unmute you for a
email.
moment so you can tell me.
I cannot do the chat. Can you hear me?
I can hear you.
I can hear you, yes.
Oh, sorry.
I don't know how to use the chat.
Okay.
And my,
I will let Cherish know. She has another. Judge Rovner, are you able to view the
She has
chat
another meeting she'd like
for
to have you join.
this? I'm going to
So you might check your
unmute you for a
email.
moment so you can tell me.
can you hear me now? I cannot do the chat. Can you hear me?
I can hear you.
I can hear you, yes.
Oh, sorry.
Here's what happened. My
Okay.
computer and my working.
Okay.
And I am on an iPad, unfortunately.
Understood. I will let Professor Keller know, and I'm going to mute you for now just so that I don't have two things because I was listening to the live stream as well, and I don't want to get confused about where I'm answering you.
All I have in front of me is the 29th annual. I don't see people.
Sure. Nobody's in here yet, so there's another meeting link where everyone's preparing, and I'll let Professor Keller know that you're having technical difficulties joining that other meeting.
Okay. So you're unmuted now.
Okay.
I have all of the participants muted at this time and will unmute once we begin the event, just so you know, it's intentional.
Okay, can you tell me who the finalists are?
Yes, Mia Rivecco, and which her name is
Can-
M-I-A.
Well, I'm sorry,
You're
her
unmuted
last
now.
name.
R-I-V. I have all of the
ECCO.
participants muted at this time and will unmute once we begin the event, just so you know, it's intentional. And Ryan
Okay.
Muhlstock
I
spelled.
didn't get the first one.
Oh, I'm sorry. I have multiple audio feeds. I'm trying to make sure I have it as clear as possible for you. So the first person's last name, Mia's last name, is Rivecco.
And is she for the petitioner?
I don't have that information with me
Oh.
at the moment. I'm sorry. And the other, Laura, if you want to unmute, if you could help the judge with this information, if you have it. I'm trying to make sure I have it as clear as
Yes,
possible.
so Mia Rivecco, she is for the petitioner. And then our second advocate, his name is Ryan Muhlstock. His last name is spelled Muhlstock.
Have that information.
And he's for the respondent today.
Thank you so much.
You're very welcome.
I'm sorry that, there's some problems.
Well, we're here to help how we can.
Our second,
Okay, thank you.
Ryan Muhlstock. His last name is spelled Muhlstock. And he is for the respondent today.
Thank you so much.
You're very welcome.
I'm sorry that, there's some problems.
Well, we're here to help how we can.
Okay, thank you. Oh my. Oh my.
Hello, Judge.
Hello, how
Oh my
are you?
God, you are a sight for sore eyes. How are you doing?
We're managing, dear. It's rough.
Yes.
We
It's
are
very,
live on YouTube. We are live. Hi, Judge Rovner.
hi, how are you, Cherish?
I'm doing fabulously. We are live on YouTube right now.
But I only see one of you at a time.
Click on,
Gallery view.
Go to, yes.
Click on what?
Gallery view.
Let's see if I can find it.
On the
Oh,
upper right-hand
I
corner.
don't have gallery view. I have participants.
There you go.
There we go.
Okay.
Well, I only see you, Cherish.
You probably are on speaker view. That will be okay because then you'll see who's talking.
Oh, okay. But I want to control Professor Namod. How can I do that? Oh, and not to speak of Judge Erickson.
How are you?
Okay.
Alive. That's about it.
We are, and we're all doing the best we can in these very unusual and trying times.
You know what? I wonder if, I don't know. I hit participants.
That will give you the list of participants on the right. I'm not sure exactly how the YouTube, how the iPad functionality works.
Yeah, let me,
different.
can I take a minute to get my technical expert?
Oh, you bet.
Oh, technical expert. Oh.
hello to the two finalists, by the way. Congratulations on how far you've come so far.
Thank you.
Thank you
Lots of
very
fun.
much.
We're looking forward to this very, very much.
Hi, Bora.
Hi, Judge Erickson. How are you?
Good. How are you?
I'm doing well. Thank you for being here. Thank you to all the judges.
Yes, I am very grateful.
I can't get gallery view, dear. Can you do it? Okay, how?
And just as a reminder, we are broadcasting, but it's okay.
Okay. Hello, everyone.
There we go.
Oh, wow.
Oh, do you see everyone now?
I do, and you're all so beautiful, every one of you. All right.
All right. Well, let me just first briefly say thank you to everyone who is tuning in on YouTube. Thank you to our judges, Judge Rovner, Judge Erickson, and Professor Namod, now Judge Namod for the day, and to our advocates and to our clerk of court who are here for the 29th annual Ilana Diamond Rovner moot court competition. We're so glad you all could join us in this very different platform. That said, good advocacy is good advocacy, and so is great advocacy, and great advocacy is what we will see today. I will leave the screen, and then our clerk, our moot court president this year, will go ahead and open our court, and then judges, it is in your hands.
The Honorable, the Chief Justice, Justice Rovner, and the Associate Justices, Justice Erickson and Justice Namod of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, everyone. We are here today in the Supreme Court of the United States to hear the case of Roxanne Torres versus Janice Madrid and Richard Williamson. Are you prepared, Ms. Rivecco?
Yes, Your Honor.
Then you may begin.
Thank you. Good afternoon, and may it please the court. My name is Mia Rivecco, and I represent Ms. Roxanne Torres, petitioner in this matter, who was shot twice in the back by respondent police officers as she fled in fear for her life. I'd like to please reserve 2 minutes for rebuttal.
Of course.
Your Honors, the issue that this court is faced with today is rooted in the core Fourth Amendment value of personal liberty and an individual's right to bodily autonomy. Every violation of a person's bodily integrity is an invasion of their liberty, and it should be treated as such in our seizure analysis. For the following 2 reasons, this court should adopt the rule that any intentional application of physical force constitutes a seizure. First, the purpose of the Fourth Amendment is to preserve personal freedom, and seizures by physical force undermine this purpose, regardless of the potential detainee's ultimate submission. And second, seizures by physical force are distinct from seizures by a show of authority, and the 2 should be governed differently.
Ms.
Therefore-
Rivecco, may I interrupt you for a moment? Is the standard for a seizure under the Fourth Amendment the same as the standard for custody under the Fifth Amendment?
No, Your Honor, the standard for a seizure is only that which restrains liberty in some way, which is a lower bar than custody under the Fifth Amendment. As this court outlined in Terry versus Ohio, a seizure occurs when a law enforcement officer in some way restrains the liberty of a citizen, and a restraint of liberty does not equate a termination of movement or total acquisition of control. There are many types of liberty interests, and this speaks to the heart of my first point, which is the
before you get to your first point, is a person who is seized for Fourth Amendment purposes entitled to Miranda warnings under the Fifth Amendment, and why or why not?
Your Honor, an individual who is seized is entitled to their Miranda rights. However, when the physical force seizure occurs, this may happen before there is an opportunity for an officer to deliver the Miranda rights under the Fifth Amendment. And when the individual is eventually in custody, then they have the right to their Miranda rights being read. However, in a case such as the case at bar, Ms. Torres was struck as she was fleeing, and there was no real opportunity for the officers here to read her any Miranda rights. And the physical force seizure rule that petitioners are advocating for today would not always leave that option available to an officer, because it doesn't matter if the individual is ultimately detained or not, and the officer may never have the opportunity to actually speak to the individual. As is the case with Ms. Torres here, the officers discharged their weapons at her 15 times per the joint appendix on page 104. Of those 15 bullets, she was struck twice and her arm was temporarily paralyzed per pages 31 and 25 respectively. This is what this court has considered an arbitrary and oppressive interference by law enforcement officers, which is at the heart of the Fourth Amendment protections as outlined in the United States versus Martinez-Fuerte.
Counsel, excuse me, I ask you this question. If we rule in your favor, has your client prevailed, or are there other issues that might get in the way?
Your Honor, there are other issues that would need to be litigated apart from the issue of whether or not a seizure has occurred at all, namely whether or not that seizure was reasonable and whether or not the officers are protected by qualified immunity. The problem with the seizure rule as it currently stands is that Ms. Torres never had the opportunity to have her day in court to argue whether or not this was reasonable and to argue whether or not she should overcome the qualified immunity of the officers. And this is foreclosing claims from individuals who have had their liberty deeply imposed upon and who should have the opportunity to present to a jury the oppressive interference by law enforcement officers to determine whether or not this was a reasonable use of force.
Counsel, let me ask you something, just two parts, two questions, and they go to the facts that you're talking about here. First, when is the specific instant, because it has to be a specific instant, when the seizure occurred? When did this seizure occurred? But more importantly than that, we're going to, I think, talk about first whether the conduct of the officers was reasonable or not reasonable. And only an unreasonable search is going to really be looked at here. Was it not reasonable that she put the car in motion, was backing up and then taking off to run away? Was their conduct not reasonable then to fire their weapons? And she was able to drive 75 miles and there was no physical contact. And then she went to the hospital. No, then she stole another car. Then she went to the hospital, spent the night, and they don't even see her for another day. So could you point in that comes to me about 36 to 48 hours of time when this seizure occurred, if at all?
Your Honor, to answer your first question, the seizure occurred the moment Ms. Torres was struck with the bullet. In this instance, two separate seizures occurred because she was struck with two bullets.
The missed bullets don't count.
Correct, Your Honor. The missed bullets do not count. It is only that contact that an individual's body suffers that constitutes the seizure.
Now, Hadari D states that a seizure is a single act and not a continuous fact. Are you contending that she can get around that language by claiming that she was essentially seized multiple times? In other words, she was seized when she was shot, you maintain, and then seized again when she was formally arrested? What?
Your Honor, the two seizures that occurred under the instant facts were the two individual bullets that struck Ms. Torres. And it is reasonable to consider these two separate seizures because where an individual may be contacted by police multiple times, for example, if somebody is shot 17 times by an officer, the first bullet may have been reasonable, but bullets 2 through 17 may not have been. And
okay, so when was she seized in that hypothetical? With bullet 1, with bullet 17, with when?
Each bullet would be an individual separate seizure. And
so she was seized 17 times?
Yes, Your Honor, and each individual interaction constitutes its own reasonableness analysis. For example, in Ms. Torres's case, it may have been reasonable for the officers to shoot once, but the 15 shots may be unreasonable. And Ms. Torres never had the opportunity to argue that, which goes to the second portion of Judge Erickson's question as to whether or not in this instance, the gunshots were reasonable. Here, Ms. Torres never had the opportunity to litigate this issue, and there is conflicting depositional testimony on the joint appendix on pages 107 through 109, whether or not the officers were in the pathway of the car and if they were truly in jeopardy of being hit. This is a factual issue that should have been argued to a jury for their decision to be made.
Well, would the petitioner be without any remedy if this court concluded that she was not seized by the bullet, or would she have a remedy against the officers under tort law. In other words, what makes this act a constitutional deprivation as opposed to a simple tort?
Your Honor, some states do allow citizens to bring state law battery claims against police officers for the force that they are using. However, the vast majority of states do not. And that is one reason why this court should adopt this broader rule to allow more individuals to seek this redress. There's also the opportunity to maybe bring a due process claim. However, that has a higher shocks the conscience standard, and it is less likely that more plaintiffs will be able to prevail under that avenue.
So if in fact the finding if it was litigated, the finding was the conduct was reasonable. After all, they were there with an arrest warrant for her. The probable cause had been established, correct?
No, Your Honor, the arrest warrant was not for Ms. Torres. It was for a different individual.
Then why did she run?
Your Honor, per the joint appendix on page 23, Ms. Torres thought that these officers were carjackers, as she had been carjacked in Albuquerque before. She had experienced this and she was in fear for her life and did not submit because she thought these individuals were a threat to her life.
For 75 miles, she was in fear for her life and then stole another car, then left when she thought the police were coming. She was still in fear?
Your Honor, the moment at which fear for her life stopped is unclear. However, after she was shot in that apartment complex, her arm was paralyzed at that moment. And she did testify that she thought she was going to bleed out from these bullet wounds. So she continued on seeking medical attention to save her own life, ultimately.
Does she rely on the fact that she was partially paralyzed by the officer's bullets to establish seizure? The bullet did restrict her movements in a literal fashion. So is that enough for a seizure?
Yes, Your Honor, that would be enough for a seizure under a physical force seizure rule. However, even less of a paralyzation would be required because any bodily infringement is an infringement on one's liberty. Turning to my second point.
Counsel, may I ask you to go back for a moment? Judge Rovner asked a very interesting question about other remedies, and you responded in part with a possible substantive due process claim. And you then correctly said the standard is higher. And as you know, the standard is probably purpose to do harm. So if in fact, theoretically, there are two causes of action available, theoretically, Fourth Amendment and substantive due process, is there any reason for us to prefer one to the other?
Your Honor, because the Fourth Amendment has the reasonableness standard, this is a preferable avenue for plaintiffs to seek their redress because it is holding officers to an accountability that is being sought nationwide right now. This reasonableness is an appropriate level to expect officers to use the life-threatening power that they've been entrusted to protect and serve the American people.
I appreciate that the Fourth Amendment argument would seem to be a little more favorable to plaintiffs, but I'm just wondering if there's anything that we've said in any other opinions where when we have to choose between a Fourth Amendment approach or a substantive due process approach, we opt for one or the other. Does anything come to mind?
Your Honor, I see my time has expired. May I please answer your question?
With pleasure.
Your Honor, in County versus Sacramento versus Lewis, this court established that when an individual is contacted with the intent to restrain, such as is the case here with Ms. Torres, that this claim should be brought under the Fourth Amendment and not as a due process claim. Thank you.
Thank you very much. Thank you, Ms. Rivecco. And now we will hear from the respondent, Mr. Muhlstock.
Good afternoon, Your Honors, and may it please the court. My name is Ryan Muhlstock, and I am here today on behalf of the respondent officers in this matter. Your Honors, a seizure under the Fourth Amendment occurs when an officer, through means intentionally applied, terminates a suspect's freedom of movement that results in the officer's control over that same suspect. To state a claim for excessive force under the Fourth Amendment, a plaintiff must first demonstrate that she has been seized. In the instant case, the district court and the 10th Circuit both agreed no seizure had occurred here because respondents never took control over Ms. Torres when she evaded capture for over a day and fled for over 75 miles. Without a seizure, there is no Fourth Amendment claim. Therefore, this court should affirm—
Seizure, forgive me, but if seizure requires that officers assert physical control over the suspect, then why is that standard not met by a bullet that causes partial paralysis?
Your Honor, temporary moments of pause is not the termination of freedom of movement that leads to the desired required amount of control to effectuate a seizure by physical force.
So must the seizure be over the entire body of the suspect for it to be a seizure?
No, Your Honor, the officers must achieve a level of control over the suspect in question. And that level of control can be met by some degree of compliance that communicates to the officer that they are in control over the situation. And that brings me to my first point.
1 second. Does Mendenhall require anything more than restraint of freedom of movement?
Your Honor, United States v. Mendenhall applied a show of authority analysis where there was no application of physical force. It only required a suspect to submit some sort of coercive act of the officers in that case, such as a overwhelming force of officers or asking some questions to those officers. But a failed attempt to seize a suspect is not a seizure under this court's precedent. And turning to my first point, in Terry v. Ohio, this court illustrated that the government violates those Fourth Amendment protections when an officer actually terminates or restrains an intended citizen's movement because it brings that citizen within the government's control. Thus, an attempted seizure without control does not infringe on a liberty of a citizen. An attempted seizure is exactly what we're dealing with in this case.
You know, removing a bullet from a person's body triggers Fourth Amendment scrutiny. Why should we treat shooting a person, essentially putting a bullet in a person, any differently? Is shooting a person more or less intrusive than removing a bullet?
Your Honor, that's a great question, and I'll answer it in two parts. First, the purpose of the Fourth Amendment was not to eliminate all contact between police and citizens. And this court did hold in Tennessee v. Garner that there is no question that the apprehension of the use of deadly force is a seizure by physical force. But in the instant case, Ms. Torres retained her ability to move and evaded capture for over a day. And second, this court continues to use a balancing test to weigh both the interests of government with the interests of private citizens. And indeed, law enforcement is a confrontational profession, and modern police force job is to investigate and arrest suspects.
But counsel, excuse me, because what you just said really goes not so much to the question of whether there was a seizure, but to the question of whether any seizure was reasonable, right, under the circumstances. But let me ask you a question that I think is maybe important. Do you have any particular theory of constitutional interpretation that you are putting forward?
Absolutely, Your Honor. It is the plain meaning and reading of the text of the Fourth Amendment. The Fourth Amendment uses the word seizure, a clear word that means in modern contemporary definitions as the act of capturing or taking control over a suspect.
But what about the Fourth Amendment in its original meaning?
Yes, Your Honor. And this court's most recent Fourth Amendment jurisprudence has articulated that there might not have been a clear answer that existed in 1791 that definitively would settle the issue here on appeal. And in 2017, this court in Manuel v. City of Juliet held that the term seizure applies most directly to the act of taking a person into custody and control. And modern definitions continue to comport with that same meaning. The common law of arrest doctrine applied most directly to taking a person into custody or taking possession over that person. And at the
What if the police shot the petitioner? not with a bullet, but with a tracking device, one that penetrated her skin like a bullet and could not be removed, would she be seized for Fourth Amendment purposes?
Your Honor, she would only be seized for purposes of the Fourth Amendment if those officers were able to take control over that suspect in Your Honor's hypothetical. And there would have to also be some degree of restraint of freedom of movement. Your Honor, the acquisition of control in seizures by physical force has been always ruled a condition of all types of seizures. And in Brower versus County of Inyo, this court reinforced that idea and held that because the plaintiff in Brower was stopped by the very instrument set in motion by the officer's roadblock, he was seized within the meaning of the Fourth Amendment. And applying that rule to the instant case, it is clear respondents intended to stop Ms. Torres, but she was not stopped by that very instrumentality set in motion. And as seen on Joint Appendix, pages 30 to 35, continued to flee, elude capture for over a day, and she committed further crimes along the way when she stole a vehicle. Page 30.
Your rule seems to depend on a person submitting to an officer's authority before we find that a seizure occurred. It appears here that she didn't know that these were police officers. How does that apply when the suspect doesn't know whether the persons attempting the stop are police officers rather than robbers or worse?
Your Honor, the analysis is an objective one that should highlight the split-second decisions officers have to make in these types of rapidly unfolding and dangerous situations. And this court reiterated in Terry versus Ohio that the police need an escalating set of flexible responses to handle all of these unique interactions with citizens relative to the information they possess at that moment. And as reflected in the Joint Appendix, page 52, respondents were scared for their lives when Ms. Torres drove her vehicle at them. They were at the scene of the crime to arrest a suspect that they had reason to believe was violent, and they approached Ms. Torres believing that that was the suspect, and she made an act of violence, and those officers acting accordingly. Part of a modern police officer's job is to not only protect themselves, but the public by investigating and arresting alleged suspects.
Your definition of seizure seems to depend on what the suspect does rather than what the officer does. Should we be assessing seizure from the point of view of the officer's actions or the suspect's actions?
Your Honor, the test remains objective, and whatever the means deployed by the police, the endpoint is the same. A suspect is either under control and therefore seized, or she is not. And without that termination of movement that leads to control, there is not a seizure and constitutional violation, but only an attempted seizure.
Pick up on Judge Rovner's point for a minute then, in terms of where are we going and whose view we're going to determine weigh reasonableness. Are we going to look at simply, and you could hear it said every day, if you ask the officer, would you let him go? If the officer says no, you pretty much got a seizure. On the other hand, if you ask the person who is the object, did you think you could go? When do those two things meet to become reasonable? And when does it become a seizure for you? Or do you disregard one or the other?
Your Honor, under seizures by physical force, the standard has always been by this court that we do not analyze the reasonableness of that force until a suspect has been seized and under control, because that is the constitutional infringement. And indeed, the control has always been the standard by this court. And in all of these seminal Fourth Amendment cases that this court has ruled over in Tennessee versus Garner, Terry versus Ohio, Brower, Hoderi, the common denominator has been that there is some degree of termination of freedom of movement that has led to some degree of control.
Counsel, I'm a little confused. Are you suggesting that there is no Fourth Amendment interest in physical integrity, that it's all about movement?
Absolutely not, Your Honor. The constitutional infringement is that act of control over a suspect. And nowhere in the text of the Fourth Amendment does it suggest that anytime an officer uses physical force, he or she is violating the Constitution.
So let me rephrase my question. Bodily integrity, is that protected by the Fourth Amendment?
Yes, Your Honor, and that bodily integrity is violated by the act of control by the officers. So that brings me to my second point, Your Honor.
What if the wounded suspect is the passenger in this scenario rather than the driver? If the suspect has no opportunity to submit to any sort of police authority through no fault of her own because the driver leaves the scene carrying the passenger, can we really say the passenger wasn't seized?
Your Honor, yes, that would fail the intent requirement of seizures by physical force. And this court in County of Sacramento versus Lewis held that when an officer made contact with an unintended suspect, there was no seizure by physical force. And the same would apply in Your Honor's hypothetical. Turning to my second point, by expanding the meaning of the Fourth Amendment and lowering that threshold for seizures by force, the rule becomes every intentional interaction between a police officer and a citizen could be subject to Fourth Amendment scrutiny. And in this sense, broad historical contexts are dangerous because when constitutional text is too broadly expounded upon, anything can be construed as a right. Indeed, no constitutional right comes in the absolute form. In this case, mere touch is effectuating a seizure, then where does it end?
Plaintiff is not arguing that the mere touch constitutes a seizure. Is the plaintiff doing that here?
Your Honor, it is respondent's interpretation that is the rule. The caliber of force that is could effectuate a seizure by physical force under petitioner's rule is unclear. It could range from a mere touch that is subjective to some sort of subjective intent to restrain a suspect.
Well, but the touch itself can be related to taking control over a person's body. I'm talking about bodily integrity. A touch would not do it as a seizure, but breaking the skin, cutting, something of that sort would be a seizure, like a bullet that just nicks you would be a seizure. What's so bad about that? You go into the reasonableness question anyway.
Well, Your Honor, for example, if we return back to that hypothetical in the situation of Broward versus County of Inyo, where there was a seizure by physical force when the driver of the vehicle crashed into the roadblock, and that was the acquisition of control this court held to be a seizure by physical force, petitioner's rule is to say that if a suspect in Broward had but grazed that roadblock and continued fleeing for 75 miles, there would be a seizure by physical force.
Well, not the car. We're talking about bodily integrity. The car itself grazes it. I wouldn't argue that that's a seizure. But if somehow the body of the person running away hits that, and there is breaking of the skin and some sort of physical harm, can't you argue that that is indeed a seizure?
No, Your Honor. A plain reading of the Constitution says that a seizure is the acquisition of control over a suspect. So in Your Honor's hypothetical, if a suspect is able to have just but grazed and sliced her arm and continued fleeing for 75 miles like the instant case, there is no seizure. And attempted seizures, the Fourth Amendment should not be broadened to encompass all these types of attempted seizures because—
But Hodari says it is.
Your Honor, Hodari said that the Fourth Amendment ought not to be expanded to cover continuing or attempted seizures. And the narrow question there was whether a suspect who, in course of fleeing from an officer before he was touched, was seized. And this court used a show of authority analysis to answer that question, but held that Hodari was only seized once he was tackled to the ground and thus terminated his freedom of movement that led to a degree of control by those officers. Your Honor, a bright line rule requiring control is essential to guide police officers who have to act in these split-second decisions, but it also helps public safety.
You know—
Qualified immunity. Go ahead, Judge.
Oh, go ahead. No, please.
I was just going to throw out the notion of qualified immunity. Police officers have a great deal of protection already with respect to qualified immunity and even the reasonableness inquiry.
Your Honor, I see that my time's expired. May I briefly answer your question?
Of course.
Your Honor, to return back to the balancing test that this court uses to analyze its Fourth Amendment claims, qualified immunity adequately represents the interests of government actors it is a doctrine intended to shield them from misconduct that didn't violate clearly established law, and it makes sure that they continue to operate in an environment where any sort of physical force wouldn't automatically effectuate a lawsuit. Thank you.
Thank you. Ms. Rivecco.
Petitioner has 1 point on rebuttal, namely that respondents' proposed rule too narrowly limits this court's Fourth Amendment holdings. In California versus Hodari D., this court explicitly stated that common law arrest is still the quintessential seizure of the person, and that doctrine indicates that any application of physical touch constitutes a seizure even if an individual can evade capture. Furthermore, this court in Boyd versus United States clearly explained that the rights of personal security should be liberally construed because too narrow a construction deprives the protection of its efficacy. Therefore, this court should reverse the decision of the 10th Circuit Court of Appeals below. Thank you.
May I ask one question?
Of course.
Thank
Certainly,
you.
Your Honor.
Thank you, Your Honor. The question is, do you have any particular philosophy of interpretation here?
Your Honor, the petitioners are adhering to the common law arrest doctrine as the underpinning philosophy for the seizure rule.
Originalism?
Yes, Your Honor.
Okay, thank you.
Thank you very, very much. We will take the case under advisement.
Terrific.
Very good. Great. Thank you.
Thank you.
Thank you all very much. Thank you to Judge Rovner, Judge Erickson, and today Judge Nahmad, and to our advocates, Mia Rivecco and Ryan Muhlstock, and of course to our clerk of court, Bora Nandrojoni. Thank you for your service too. This has been a wonderful round. Thanks to everybody who was joining us on YouTube. Now our judges will retire to their judges' chambers and via a breakout room from our clerk, and we'll discuss the case amongst ourselves. Thank you to all of our judges. They're listed on the screen too. Our program would not be the success it is without all of you. And end our live stream.
Thank you, everyone.
Thank you.
Thank you.
Thank you.
Okay, do we just wait for a breakout room?
Yeah,
I-
yeah,
Yeah.
yeah.
I'm
Okay.
opening them up right now. I just had to assign you all. Thank you
That's
for
fine.
Ryan, you can go ahead and leave, and I'll see you in the awards Zoom room.
Great. Thank you so much, everybody. We really appreciate it.
Bye,
Thank
guys.
you.
Pleasure.
Thank you. Thank you.
All right, they should be open now, so you
Yeah,
can,
join breakout.
yes.
Bora, if you could make me a co-host, then I can end the live stream officially.
Yes, sorry, I just did that. Did it work?
I believe so. No, actually, you as host are the only one with action. So if you click on more in your meeting controls, you should have a stop live stream option.